The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 20th of April, 2016, are currently trading with gold at $1,253.14 an ounce, silver $17.14 an ounce, Texas crude $41.08 a barrel, and Bitcoin is currently at about 440 U.S. currency. Today in history, the year 1999. The Columbine High School shootings take place in Colorado. 13 people were killed, with 24 being injured. The Columbine shootings took place today in history. In recent news, Treasury Secretary Jack Lew is expected to announce later today that Harriet Tubman, the African-American abolitionist most famous for her role in helping slaves escape through the Underground Railroad, will soon be the new face on the $20 bill, with the U.S. founding father Alexander Hamilton remaining on the $10 paper note. The new $10 bill is set to be unveiled in 2020. The timing for the production of the new Harriet Tubman $20 bill, however, is yet to be announced. More than a dozen criminal charges have been filed today against 3 officials in Michigan as part of a months-long investigation into the lead-contaminated water crisis in Flint. The charges are the first from the government catastrophe, which has potentially exposed roughly 100,000 residents to lead-contaminated water. As a result of this, which many are calling criminal negligence, the crisis has led to an investigation of the possible links between the tainted water and a dozen deaths from Legionnaire's disease. In 2015, local, state, and federal authorities through the Drug Enforcement Administration's controversial cannabis eradication program uprooted roughly 4.1 million cultivated marijuana plants in all 50 states as compared to the 4.3 million plants in 2014. While federal spending on the program has remained roughly the same at $18 million in the last few years, it tallies out to roughly $4.42 per plant. This DEA's program provides funding to 128 state and local law enforcement agencies to search for, seize, and destroy marijuana being grown across the country. Much of the money for the program comes from the Justice Department's highly controversial and constitutionally questionable asset forfeiture fund. However, at least 2 states have declined to accept federal eradication funds last year, Alaska and Colorado, where marijuana is now legal. 4 states, including even the District of Columbia, have legalized marijuana for adult use, with several other states hoping to follow smoke this year. With an ever-growing opposition from researchers, lawmakers, doctors, and the general public calling on the federal government to change course on marijuana policy and save us all some money. This is Rick Brody with your lowdown for 4/20/2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot and you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father, you chuck it on your brother and you chuck it on your sister, you chuck it on that one and you chuck it on me. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys.
Okay, howdy. This is Randy Kelton, Deborah Stevens, Rule of Law Radio on this Thursday, the 21st day of April 2016. Today was an interesting day. Actually, I've been waiting for this day for quite a while. Today was the day that the grand jury meets in the county that I live in. And I had prepared a set of complaints against my district judge and a Texas Ranger. And had spoken to the prosecuting attorney. Actually, we speak quite often. I've known him since he was a county attorney, and but I like to think we're pretty good friends. And I gave him the law, told him what I was going to do. He read the law. He agreed with me, and he agreed to stand aside. I filed one of the most technical claims I could against my district judge. He had a bailiff put his hand on my arm under threat of arrest in order to stop me from exercising a right. It's a bit of a long story. Well, not that long. I went to the court. I notified them beforehand. that I would be going to the court for the purpose of challenging the grand jury pool. In Texas, Texas Code of Criminal Procedure 19.27 states that anyone may challenge the grand jury pool prior to the impaneling of the grand jury and not after. So I went down and sat through the impaneling after having given notice of my intent to challenge the pool. Well, the judge impaneled the grand jury without giving me opportunity to challenge. So afterward, I questioned him about that. I wanted him to disband the current grand jury, then reassemble the pool, give me opportunity to challenge the pool, then select another grand jury. Well, he didn't want to do that. And in the process, at one point threatened to have me arrested. The bailiff came up and put his hand on my arm, and when he did, I asked the bailiff if that pistol he was wearing was loaded. And the bailiff assured me that it was, and apparently the judge got the idea because I wasn't responding the way he expected me to. I guess he expected me to shiver in my boots or something, but I didn't. And when I asked the bailiff about the loaded pistol, that seemed to let him know something else was going on. So he had the bailiff back down, and I finished up my business because it was obvious I wasn't going to get an opportunity to challenge the grand jury pool. But I considered that touching as offensive touching, and it was considered to be intended as offensive touching by the bailiff, letting me know of his intent to arrest me and letting me know that I had better not resist, or he was prepared to do bad things to me. That's the way he meant it. That's the way I took it. And he did so in order to prevent me from exercising a right. But he only did so at the direction of the district judge. So it was my position that he did not commit assault against me. The judge committed assault against me, and he was the deadly weapon the judge used. Texas Penal Code 2202 says if a person commits simple assault as defined by 2201 and they are prominently displaying a deadly weapon, that is a second-degree felony in the state of Texas. However, if the person is a public official acting under the color or pretense of an official capacity, it is a felony of the first degree. See, our legislators, when they authorized a person to strap a loaded pistol on his hip and to do so under government sanction, they intended that that person treat that weapon as something very, very dangerous and to be extremely careful, because if they misused their office at that, once they had the deadly weapon on, they made the crime extremely serious. Well, that's the way I read it. I took it to my local Texas Ranger. And in September of last year, a new law went into effect that moved the Public Integrity Unit. The district attorney for Travis County got the legislature to authorize funding for a Public Integrity Unit for the district attorney's office. Well, he used that Public Integrity Unit to take out Tom DeLay, the Speaker of the House, by indicting Tom DeLay when nobody had ever filed a criminal complaint against him. He was never accused of a crime, but he was prosecuted anyway. And then Lumberg, if I'm pronouncing that right, the subsequent district attorney used the same Public Integrity Unit to get criminal charges filed against the governor of the state. So the Republicans in the legislature put an end to that nonsense and removed the Public Integrity Unit from the district attorney to the Texas Rangers. Well, prior to this time, a Texas Ranger could investigate a public official, but only with the written permission of the director of the Department of Public Safety himself. All investigations of public officials by Texas Rangers were under tight political control. Well, the legislature come along past this new law, and it threatened to take that tight political control away from the politicians. So when the department developed a set of protocols for implementing this new legislation, they required that the Texas Ranger get permission to investigate a public official from the prosecuting attorney, because it was the Texas Rangers were given the right to investigate, so the director had no more standing to interfere. So they directed him to the prosecuting attorneys. And I maintained that that was a violation of Article 2.03 Code of Criminal Procedure and a lousy trick trying to get political control back toward complaints or investigations for public officials. So I filed a complaint with Texas Ranger, and he followed that protocol. And I charged him with official oppression for doing so, misfeasance in office, failing to present the complaint to some magistrate the way Article 2.13 commanded him to do. And I filed both of those with the grand jury today. I also accused the Ranger of criminal conspiracy. I accused the Ranger of conspiring with the director of the Department of Public Safety for the purpose of interfering with the execution of a law and attempting to engage prosecuting attorneys in a conspiracy to obstruct justice. Went down to file those today, and when I walked into the building, the stairway going up to the second floor is right in front of the Commissioner's Court. And there, standing in the Commissioner's Court front office, was the district judge that I was filing against. When I started up the stairs, he came out and followed me up the stairs. That got tense. I got the distinct impression he wanted me to engage him in conversation, which I strictly declined to do. He didn't say anything to me, but followed close behind. I just walked into the district attorney's office and had about a 30-minute conversation with the district attorney about the specifics of some really technical specifics about the filing I was making. The district attorney came out to the front office to talk to another lawyer there to make to question her about whether or not I could get the voting record of the grand jury, because I wanted to find out how to tell if a complaint filed with the grand jury was no-billed. The grand jury is required to come before the court with the form of the grand jury president and read the fact of the indictment onto the record to the court, and the clerk shall make notes in the minutes of the court. It doesn't say anything about a no-bill. So if I file a complaint with the grand jury and they no-bill, it's like it drops in a well. It disappears. So I don't really know if they actually got it and heard it. I don't have anything showing that they actually heard it. I only have something showing if they true bill. So I'm trying to trace it down. And so we're having this discussion, and the district judge walked into the district attorney's office while I'm standing there, and the district attorney is there. The judge never said anything. He just stood there a couple minutes, I guess, waiting for somebody to speak to him, and nobody did. But it got real intense in there. That was incredibly improper. And the district attorney, he don't give away much. But after the judge walked out of the office, I turned and looked at him, because I was talking to another attorney, and we never interrupted. We didn't lose a sentence. We paid no attention to it. I looked at the district attorney, and his eyebrows cocked up just a little. I think he was furious at the judge, that was so incredibly improper. So it was interesting. They are filed. If we can get the ruling I want, we could change everything in Texas. Hang on. Jeff Kelly, I see you there. We'll pick you up when we get back on the other side. Randy Kelton, Deborah Stephen, Rule Law Radio. Our calling number 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule Law Radio. And this is important because what I filed against the judge was really striking a very fine line of law. There is no way on earth that a prosecuting attorney in his right professional mind would ever charge anyone with what I charged this district judge with. And I charged this district judge with this because I absolutely did not want him indicted. I could have charged him with official misconduct or official oppression, and I might actually have got him indicted, and that's not what I wanted. I could have charged the Texas Ranger differently and might have got them, but I didn't want either one of them indicted. What I wanted was the judge to have to face the prospect of indictment. I talked to the district attorney about this, and I told him my whole purpose was in this particular filing, was to get the Texas Rangers to go to the Department of Public Safety, who they work under, and tell them what in the heck is going on. Why is one of us being taken to a grand jury for following your policies? So you need to fix those policies. If we can get the department to change the policy and put the ranger in the position the legislation intended and allow them to investigate public officials the way the law authorized them to do without political interference, we will change everything. Now, a public official want to do something that appears to follow policy but it's in violation of the law, and I bring it to them, they will have good reason to change that policy because they're not going to want the Texas Rangers investigating them. If there is one group in Texas, one group of peace officers that I would trust to do the right thing without regard to the politics, it'd be the Texas Rangers. But even if they don't, it will give the appearance of effective oversight. And the fact that I'm able to present these public officials to a grand jury. I told the prosecutor that I wanted the Rangers to be the ones to stand up to the DPS. And if I file this, they'll find out about it. And he said, yeah, in about 45 seconds. That's how fast the phones would go. So regardless of what the grand jury does, my purpose has been served by the filing. We get this opened up and we get other people going to grand juries. And I have other people. One of them is our call screener. He's been going to grand juries. We get people going to grand juries against these traffic court judges, against public officials who are following flawed policy. We get these policies fixed. Okay, that's my story, and I'm sticking to it. I'm going to go to Jeff in Mississippi. Hello, Jeff.
Hey, Randy. Thanks for having me on.
Glad to have you. What are you up to this week?
Well, my case for having a rifle on the campus of Mississippi State University is up for appeal, and my public defender, my public defender, yeah, my public defender just wrote me a letter saying that she will not be arguing my case. So I am now typing up my own brief.
Did you also bar-grieve your public offender?
Okay.
Bar-grieve her and send her a notice of tort.
Tort letter, okay.
Yeah. She had a duty to represent you, and she's refusing to represent you. Give her notice that she's denying you in due process.
Okay, good.
Well, a bar-grieve is a sting 'em, but not near as bad as a malpractice suit will.
Which is tort letter first.
Tort letter first. Before you file a civil action, the courts ask you to effect administrative remedies. And the only administrative remedy that they require is notice and opportunity. If someone has harmed you, the courts want you to give them notice and opportunity to make you whole. So generally a tort letter ends with, make me whole or be sued.
Okay.
And then that ought to get her hopping. So what was her reason for refusing to? Okay, how did she become your lawyer? Was she appointed?
Yes, appointed public defender.
Oh, this should get a petition for mandamus to the Court of Appeals.
And she wrote me a letter and an email, did not give a reason. She just said, I've looked through your transcripts. I don't find anything that I can argue in your case. And then she sent me a brief, her brief, and it says that under the statement of facts that I had a rifle on Mississippi State University, and it says summary of arguments, and it says none. So she basically said, I will not be arguing or I don't see anything to argue in your case. And, of course, you were talking to me on the phone during my trial. And I went in there and loaded them up.
So now take that letter and send it with a petition for writ of mandamus to the Court of Appeals and ask them to order your attorney, demonstrate, you write your brief and send it to the Court of Appeals as a sample of the issues this lawyer should be addressing, and ask the Court of Appeals to issue a writ of mandamus.
All right.
And order the lawyer to represent your case.
So go ahead and type my brief, my version of the brief, because I'm already doing that now. In fact, I'm almost done. I've been working day and night.
Yes, get that to them. Say, this attorney can find no issues to argue. Well, I'm able to find some. And if I can find some, the lawyer certainly could. So the lawyer has been paid to represent you. She has been appointed as your attorney. She has a duty to represent you. And you don't care if she wants to represent you or not. That she has a duty and you have a right to representation. And let's see what the Court of Appeals says.
And this is the State Court of Appeals that I'm already currently in.
Yes, exactly.
Okay. Now, there's a section...
That should get really interesting.
Okay.
Frankly, I've never heard of that before. I've heard of lawyers wanting to be removed, but not of one saying they can't find any issues to argue.
And there are some good issues.
This could get her sanctioned big time.
Okay.
You might actually wind up taking a lawyer's bar card. Mm-hmm. This is really serious. And as due process goes, this is big time serious.
Yes.
I'm astounded that a lawyer would do such a thing. Does she really think, after seeing your history, that you're going to lay down and roll over for this? Okay, hang on, Jeff. We'll be right back. This is Randy Kelton, Deborah Stevens, Real Law Radio. Our call-in number, 512-646-1984. We'll be taking your calls all night. Kelly, I see you there. We'll pick you up when we get done with Jeff here on the other side. We'll be right back.
If you're struggling to fall asleep, think twice before popping that Ambien or Xanax pill. Those medications can be habit-forming and cause memory loss, even brain damage. I'm Dr. Catherine Albrecht, and I'll have the details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Insomnia makes you tired and anxiety makes you a nervous wreck. If you suffer from either one, your doctor may have suggested Ambien, Ativan, or Xanax. Those drugs, known as benzodiazepines, have serious side effects, including dependency, memory loss, and even dementia. Dr. Armin Neal, co-author of the book Are Your Prescriptions Killing You?, says those drugs can cause sleepwalking and even trigger mania and bipolar disorder. But if you think you're hooked, don't just quit cold turkey. Once your body gets used to benzodiazepines, quitting suddenly can cause permanent brain damage. It's better to taper off with the help of a doctor. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in their hand. Won't you follow the law of the land? I don't understand. The job is to protect and serve, not beat and abuse. Officer, when you gonna stop abuse your power? 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 So please, Mr. Michael, and teach officers not to abuse the power. Send a request to the leader, the captain of all officers. Tell them to uphold the law. Please don't abuse the power. The beat and the beat and the cheat and the cheat and the lie.
Okay, we are back. Randy Kelton, Rural Radio. Hey, we're having way too much fun on the break. Okay, go ahead, Jeff.
Well, my second question is, during the trial, the judge had ordered me to be arrested because I wouldn't take a plea, and I brought that up in the trial. However, I did not actually say the words object. I just said, Judge, why did you arrest me? And he refused to answer, and unfortunately I did not say object. But on my appeals brief, there is a section that says to list parties or, participants so that we, the Supreme Court, may look into recusing them. So is there any way that I can have the judge disqualified during my appeal?
Okay. Oh, that is an interesting question. This is Mississippi. It's not Texas. Mm-hmm. And I'm not sure exactly how recusal works. But frankly, this is not something that I've come across before, where you're asking the appeals court to recuse. Now, we have asked appeal courts to disqualify, and I don't see why you can't. This would seem, a lot of what I talk about here is not based on some specific, intricate knowledge of law, but it's based on what objectively, after considering both sides and the ramifications, what seems like it ought to be right, because in law it generally is. So if I'm in court and I have a judge that's refusing to recuse himself, and the administrative judge or the judges generally appointed to hear the recusals tend to be politically appointed, so they're not much help. It would seem that the Court of Appeals could object to my denial of recusal as well as everything else. So that remedy it would seem should be available. And the fact that you brought this up and questioned the judge about it is enough to support your. You don't have to say a magic word, I object. You just have to rate. You rose an objection to it because you requested foundation for the action.
Oh, okay, because I called the judge to the witness stand, and the judge refused to get off the bench and get on the witness stand. Unfortunately, I wasn't fast enough to object. We just moved on, unfortunately. But
wait, that's enough. You called him. Okay. He refused. You don't have to wave a magic wand and say, I object, Your Honor. Mm-hmm. You have to, by your behavior in court, indicate that you opposed what the court did. So when you called him to the stand and he refused, that's an issue you can bring.
And so should I file a motion to disqualify the judge and send that along with my brief?
Oh, absolutely. Okay, go to an old Texas saying. If you throw enough horse dumplings up against the wall, horse dumplings tend to be dry, fibrous little things. If you throw enough of those up against the wall, one of them's likely to stick. Mm-hmm. I had a lawyer tell me that once when he read my suit against the White County Sheriff. He said, you threw everything at him but the kitchen sink. I said, well, I couldn't pick that up. And that's what he said. Yeah, put in every objection that you believe is relevant and you can sustain.
Okay.
The judges are human beings too. And if you've had kids, you understand that a human being only has so many no's in them. After a while, you really get to feeling bad about saying no. It's genetic. I watched a program where they were doing experiments with rhesus monkeys. They had two monkeys in side-by-side cages, and they'd come to the monkeys and give them carrots. The monkeys would take the carrots. They loved carrots. And then they started giving one monkey grapes and the other one carrots. The third day, the monkey refused to take the grapes until they gave a grape to the one in the other cage. The sense of fairness is in our genes. So when they're saying no, 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 it just in us. We get tired of saying no all the time. We want to throw you a bone. So if you think you can support it, put it in there. Unlike a lawyer, you don't have to have the strict case law support that a lawyer does. So you're just a dumb pro se. So they don't expect as much of us. So they'll sanction lawyers for filing improper legal arguments, but not pro se. So go ahead and put it in there. Just think about it from the objective standard. If you were a neutral party looking at this, would this appear to be wrong? If the court rules against you, could another party look at this ruling and use it to create a bad result? Because that's what these appeal courts judges are looking at. They have a different agenda than trial court judges. Trial court judges, they hear the same complaints over and over. And, I hear people complaining about judges dozing on the stand. That's because they hear the same stuff over and over and over. And they deal with the facts and the law. The Court of Appeals, they deal with the corpus juris, the body of law. And they need a body of law that is sustainable. They don't want to issue a ruling that appears to be just in this case, but that a shyster lawyer could take this ruling in another case and create a horrible outcome. And you see this in the case law all the time, where they issued a ruling and it had unintended results, and they have to go in and overturn the ruling because it appeared just on its face, but it affected the body of law. So when you're writing your pleadings, keep in mind, these judges, they're looking at the body of law. If they rule against you, you want to bring issues to them to where if they rule against you, other lawyers could take that ruling and make a mess of the corpus juris. Does that make sense?
Yeah.
So anything you think sounds just, and from both sides' perspective, because it always sounds just from your perspective, but set yourself on the other side and you're going to argue against it. If you step on the other side, it's like taking a chessboard, playing 8 moves, and then turning the chessboard around. Look at it from that perspective. If you would have a hard time arguing against this, then it's a great thing to put to file.
Okay.
That's my story, and I'm sticking to it.
Well, that finishes me up. I will give you a holler next week.
Thank you very much, and be looking forward to hearing from you. Always have good stuff. Thank you, Jeff. Okay, now we're going to go to Kelly in Pennsylvania. Hello, Kelly.
Hi, Randy. Thank you for taking my call.
I understand you are a first-time caller.
Yes, sir, I am. I just found out about you by the grace of God. Somebody on Facebook is reading my story, and let me tell you, I've already had over 30 attorneys tell me I am the worst corruption case they've ever seen in their lives.
Okay, hang on. We're about to go to break. Randy Kelton, Real Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Easy.
Not wage any battle, will your purpose has be done? Such a sentimental soldier, a warrior of love, scaffold and to keep the peace. All it taken is a misunderstanding.
Okay, we are back. Randy Kelton, Deborah Stevens, Real Law Radio, and we're talking to Kelly in Pennsylvania. Before you start into the specifics, there's one thing I have to warn you about with attorneys. Attorneys don't really work the way we tend to think they do and the way it shows on television. When you go to an attorney, initially the attorney's job is to get a retainer. That's all he wants to do on that first hearing. He'll tell you anything to get your retainer. Once he gets your retainer, he's going to use up your retainer, and as soon as he's used it up, then he's going to come to you and tell you the truth. and going to want a second retainer. So don't be too impressed with these attorneys. Okay,
Well,
I'm sorry.
Well, 2 were disbarred and 1 was suspended.
Oh, okay. Well, give me an overview of the case.
I want to ask you real quick. Somebody also said the first thing I should ask you about is there is a person, they think they remember the name Ledley in Pennsylvania, that maybe you could be reached out to.
Does your issue involve foreclosure?
That's one of them. They stole my house when I was unresponsive in the ICU unit, fighting for my life without my knowledge.
Oh, that sounds wonderful. I mean, not that you were in ICU fighting for your life.
I came out praising God because my son is a concealed carry carrier. A year earlier, 3 men broke into my house with guns and attacked and robbed me. He came to pick me up at the hospital, and the man with my oxygen was waiting in my driveway until I got there. So my son and his stepson were dragging me up to the house, and all of a sudden I'm gasping for air, and all of a sudden I hear my son say, Blake, grab her. And he literally, my son never does it. He literally throws me into the arms of his stepson, and he's screaming, who the F are you? You live off. And by the grace of God, he did not have his gun, because I know in my soul, had he walked in that house and done this by strangers, somebody wouldn't be alive today, and he would have had justifiable cause for this. So I'm so thankful for that. But right out of ICU, I had to go live in my van, because they sold my handicapped accessible home. This trustee got the deed of my home in his name, and he didn't only not pay my creditors off because I had to file bankruptcy, he pocketed all the money. But my biggest deal, because I'm very honest and trusting, I sustained 2 brain injuries. I had to get, in my 20s, I had to at least get educated in something so I could provide a living. And I provided a damn good living. I'm a stubborn as hell New Yorker chorus. So I'm a fighter. It's not that smart anymore. Trusting. So my husband leaves me for another woman. That's okay. He empties out all our bank accounts, cashes in all our mutual funds. I was the one that worked 100 hours a week. He worked 4 months a year. He then took all our credit cards, which all had 0 balances on them, and maxed them all out. He then went and stole a blind woman, 74-year-old blind woman's credit cards, and hired an attorney, leaving me living on my Social Security of $1,024 a month. So I'm trying to find an attorney that wants $10,000. I'm sitting there going, so do I. Why don't I get my $60,000 back from mutual funds? But I found this one that, oh, my God, Kelly, this is horrible. And he agreed to me. So we go to a divorce hearing. The first thing my attorney, Doug, states to the divorce master, and I'm very professional. I'm dressed very classy. He says to the master, Your Honor, with all due respect, you have no authority to hold this hearing, as there is an appeal before the Superior Court on this issue, and all the records are in the Superior Court. Master leaves the room. He comes back in, and he literally looks right past my attorney and starts screaming at me, calling me names, telling me I'm a troublemaker. I have no respect for the law. I have so many hands in the pockets, and I'm listening to these words going, these are verbatim words of things my husband's attorneys have said to me out in the street, in other places, something. And he knows my husband's attorney somehow or other. So he said, you wasted so much of the court's time, so you give your testimony. We'll take a lunch break, and your husband will testify if that's okay with you, Mr. Singleman. I said, yes, Your Honor. So I testified to the best of my recollection of all the assets my husband removed from the home, the bank accounts, so on and so forth. We leave for lunch. I come back. My attorney is standing down the hall outside the courtroom. I don't know if I can walk back there. And I kind of called his name, and he signaled me back. And we're standing right outside the courtroom face to face. And he goes, we have a problem. And I said, what's the problem? He goes, the stenographer machine malfunctioned, and they forgot to plug in the backup tape recorder. I said, well, what exactly does that mean? He goes, there's no record of your testimony. I said, so what does that mean? He goes, well, we can either ask for a continuance or it's an automatic mistrial. And I said nothing. And all of a sudden, Elgar comes and steps right in between Doug and I, and he's literally spitting in my face, screaming, you'd like that, wouldn't you? He goes, D-Night, get your effing ass in that courtroom, and if you even as much as make a peep, I will have your ass in jail so fast you won't know what to do.
Wait a minute. Who said that to you?
The master.
The master?
The one that's holding the hearing. The divorce master.
That should have got criminal charges against the master. Okay.
So I'm in the courtroom with tears in my eyes.
Hold on. I'm gonna back you up, because in order to do this is way too complex to do without some guidance. What I'm going to ask you to do is sit down and write a timeline. Not a statement of facts, just a timeline. This happened, then this happened, then this happened, then this happened. Don't explain it. Just state the happenings. No.
So just say September 4th, 2007, we had a divorce hearing. January 8th, 2008, my alimony stopped. Like that, you mean?
Exactly. And here's the reason I do that.
Okay.
So there's some recent research in how memory works. We used to think that we have memory and we go in and access our memory and read what's in the memory, like it's a library. But that's not how memory works. The way memory works is we go in and we take the memory out and we re-experience the memory, then we put it back. They were doing experiments with mice where they had the mice access memories. They gave them this date rape drug. I'll think of the name of it in a second. But the date rape drug, what it does is it keeps you from storing short-term memory. That way, people who are raped don't remember it. So they gave it to these mice. And the mice, it wasn't just that they didn't remember what happened, but they had them access memories of things they had taught the mice. And then they couldn't, then the next time they tried to experiment with the mice, that memory was gone. Now, they had this memory. They had taught it to them. And then they had them access the memory with this drug. And it turned out they go get the memory, re-experience it, and put it back. Well, when they blocked them being able to put it back, they had amnesia for it. It's really important because when we're in these kinds of traumatic situations, we tend to notice those things that traumatically affect us. And when we tell the story, we think we're going and accessing the memory, but we're not. We're going and pulling the memory out. And then we tell this story, and then we put the memory back. Well, here's the problem. When you tell me the story, you tell me that part of the story that appears to be relevant to this context. And that's the memory you put back. You tend to lose these important details because when I listen to the story, I'm not emotionally affected. And I'm listening for things. Yeah, I'm listening for aspects that you may not have even known existed.
Oh, but, sure. I know there's a lot of things I didn't know existed. But the nice thing is, Randy, I actually, in 1987, because I was so poor, I had a 2-year-old.
Stop. You're doing this. This is what we do. We get so emotionally involved in this. We're so emotionally invested in it.
Else that happened.
You're going to one emotional issue after another. Okay. If we're going to go after these guys, we need a timeline first because you can reconstruct the lost history with an effective timeline. You have a whole lot of things you could throw at me. The difficulty I have is with a concept called referential index.
Okay.
I need to understand how this particular situation fits into the overall scheme of things. I can't really evaluate what's going on unless I have the overall context. But when we access these memories emotionally, we lose the overall context. So first thing we need to do is write a timeline. And I assure you, I understand how incredibly difficult this task is. But if you write yourself a timeline, it will be the most valuable tool you will have. I'm about to go to break, and I'll explain a little more about that when I get back on the other side. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be taking your calls all night. So if you have a question or comment, give us a call. It's best you call in early because the call lines tend to build up as we get further on in the show. Hang on. We'll be right back.
Babylon, I'm born down the whole nation, but them operate the land wrong. I'm a say Republican and them a scratch man. Tell them I'm a libertarian. Them say we born to lose, but we born to win. Come rock on. Justice and peace. Child of rule this time. How what we say? Chant for our wars.
this chant. Always man. Chant of rule, this chant of peace. Chant for our words, chant for our words.
None of them when me chant, when me see. Say all man was created equally. Chant down Babylon and do it daily. And when night come, pray for everybody. So one by one, me have to chant them man. Me chant down Babylon because Babylon is wrong. The only right man, me say, is the Rasta man. We take me say Lord man, the Bowian man. To chant down Babylon.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Kelly in Pennsylvania. And Kelly,
yes, sir.
It's not that I don't want to hear all the details.
I understand.
It's that this is, you're very passionate with this, and if you go through all of these details, you're going to revivify all of this misery and all the bad things that happen to you.
Yes, sir. Yes, sir.
What I want to do is do what in psychology we call disassociation. I want to get a step away from what happened to you, and let's get down to the details. I can tell you, every time I audit one of these things, I find stuff you never dreamed of. People that are inside it. You know, I once represented myself in a criminal prosecution. I filed criminal charges against a judge with the grand jury, and they prosecuted me. And I was totally, absolutely incompetent to represent myself because I had too much. I had a dog in the hunt. And the important things that went by, I was too involved in the heat of the moment to be able to recognize them. So this timeline is an incredibly powerful tool for getting everything lined out. And once we have everything lined out, then I'm going to walk down this timeline. And with my experience in legal issues, things that should be there tend to jump out at me. Where someone who's involved in the system, they won't recognize this. I'm the technical guy. And I start saying, now, wait a minute. How did they get to this point? There should be these steps in between.
Right.
And once we have a good timeline. I want
to ask you about the timeline.
Yeah. Once we get the timeline down, and it doesn't have to be terribly complete. You just start out with what stands out in your mind. And once you have a list of it, then go back and look at it, and you'll say, wait a minute. This went on here. This happened in this space. You'll start filling in these empty spaces. And then you'll begin to develop a coherent story. And then we go to the fun part. What we want to do first is create a statement of facts. But we do that from the timeline. And we just walk down the statement of facts. You see, the first thing the judges are going to want to look at are the facts. Just the facts, ma'am. All he wants to see is the facts. Well,
yep.
It's not exactly just the facts. We're a little bit more creative than that. First thing we do is go down the timeline and look at all the facts that must be there. Even if some of the facts don't tend to lean to be in our favor, we have to address those. But once we have all the facts in place, then we make up a story. We make up a story that explains this whole situation based on the facts. And those facts that don't go to support our story, we mark those as with a orange marker or something. And once we have our story lined out, then we go back and look at these orange ones. Are these relevant? Do they have to be there? And if one has to be there, then we put it in and argue why it's irrelevant, and then keep going.
Okay.
What we're trying to produce is a reasonable person of ordinary prudence. When he reads the facts, he's going to try to put this together and make sense of it. So once we have all the facts lined out, we go back and put in those facts that will tend to cause the reader to come to the conclusions you want them to draw. And then once you've done that with the facts, then you put in a statement of factual accusation. And the statement of factual accusation follows those facts. And it makes the arguments and draws the conclusions that you tried to get the reader to draw from the way you put the facts together. If you've done that well, when you make this argument and say these facts fit together this way, he's going to think you're really smart because you're drawing the same conclusion he did.
Okay.
Does that make sense?
Yeah, and it does. But here's the question I want to ask you. What this opposing counsel does is he would keep filing frivolous lawsuits against me and bringing me in front of like district justices to make me look like a lunatic, hoping he could get me to snap because of this one thing I had, organic mood disorder, and if you push me too far, I go out of control. Do you want me to list those days too? Because I journaled every night.
Yeah, absolutely. And if you keep a journal, you're the kind of person I like to work with. I get people that keeps no records.
Oh no, sir! I journaled every night, every night, because it was my way of I had to let go of this, or this was going to keep me up for 4 days. And how can somebody be a liar when I put my hand on the Bible and I swear to God, and God's hearing all of this? And to keep my sanity, I journaled the date, the time, who I talked to, what happened, and everything I have documented in fact. So I will.
Okay, for the most part, you already have all the data you need for a statement of facts. Now all you need to do is lay out your journal. This is wonderful.
Okay.
So seldom I have people that have kept good records. So, I get somebody, they call me, so something bad happened today. This happened, that happened. This. I said, wait a minute. Sit down and write it down right now. Because now your memory's clearest. If you tell it to me, you're going to delete part of it. Linguistics, language has deletions and distortions. And
well, that's why I've been reviewing all day long since I knew I was going to make this phone call tonight. Just two major factors, because there are so many other things. And I'm trying to focus on the divorce and the modification of alimony first. But I understand exactly what you're saying.
Okay. Before you make a decision on where you think you need to focus, put together a timeline, back up, and go at it as if it was the first time you saw it. Because once you have it all together and you go back in from a third-person perspective, you may be surprised at what you see that you didn't see before.
Oh, no, I do see that. If I do go back and review it, like, okay, did I forget about that? Did I not realize what was happening? So, yeah, I do realize there were things I, don't remember or didn't understand or missed it completely. So when I do this, Randy, what do you want me to do next?
Okay. Once you have the timeline down, email it to me.
Okay.
I'll go through it, and then we'll go back online, and we'll talk about this on the air. And this is great because primarily what we try to do here, we don't really so much try to teach the specifics of law, but we try to teach people how to think about law. And this will give us an opportunity to take a complex case and then take that complex case apart into smaller pieces and then fit those pieces together in a way that makes logical sense. So this is very well worth the time.
Randy, thank you so much.
Okay, and your foreclosure issue. I do have Leslie in Pennsylvania, and I aspire to be able to write documents as effectively as she does. And the last thing I ever want to happen is to have Leslie coming after me. She rocks, and especially in Pennsylvania. But the first thing we need, we have a lot of people out there, especially on the internet, touting how to go after foreclosure issues. And it is my opinion that the banks sent people after MERS and securitization and show me the note because those are the hardest things to argue in court. The first place I want to go is to the public record. Every state has a statute similar to 13.001 Texas Property Code. And it says, any claim against real property not properly acknowledged or proven and filed in the record is void as to the holder. So when someone comes and says, well, I got this claim, I'm going to go look in the public record. You may have that claim, but if you haven't properly filed it in the public record, you use that claim for toilet paper. So the first thing you want to see, everything that's been filed in the public record since you received a warranty deed on the property. Get that, get me a HUD-1 settlement statement, a truth in lending statement, and the note.
Wait, a HUD-1 settlement statement?
Settlement statement. When you sat down at the closing table, they brought out this legal-sized document with lots of numbers on it. The second page list all of the charges that were charged to you at closing. I want to look at those charges. Every one I've ever looked at, except maybe 5 or 6, had illegal charges on it.
But if I wasn't at the settlement statement because they already transferred the deed of my home into this bankruptcy trustee's name, can I still access this HUD?
Okay, hold on. We'll get to bankruptcy. You filed bankruptcy. Did you claim the property as unsecured?
No, sir. It was secured.
Ooh. You have no duty to stipulate to anything. You may be able to refile bankruptcy and claim the property is unsecured. But first, I want to see everything that's in the public record. And then I can go down those records and tell you pretty well how you can go after them. Hang on. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Give us a call. We'll be taking your calls all night. Oliver, I see you there, and we will get to you. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took the money from my hand. Ain't gonna fool me with that same old trick again. Ain't gonna fool me.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio, and we're talking to Kelly in Pennsylvania. And I know, Kelly, I didn't go through all of your issues, and I have a good reason for that.
That's okay.
Yeah,
I know.
We get this prepped right. I'm an engineer, and engineers are hell on the details. I always find the devil in the details. I have probably looked at 1,000 foreclosures, 1,000 mortgages. I have found maybe 3 that I couldn't find a claim on. It is unbelievable how badly the banks have messed up the paperwork. And if you've had a foreclosure, even if it's done, we can still go back and you can hammer them big time. We have come to understand how the courts actually work. There's some things that people need to understand. It's not the way you have been led to believe. First off, you will never win your case simply because you have the law and the facts on your side. To think so is naive. It is not that way now, never has been that way since we've had courts. I read an interpretation of a plaque commissioned by an Akkadian king 6,000 years ago. And what it said was, those in positions of power and influence have so perverted the laws that the people can no longer secure justice. Therefore, I am reasserting the old law. If this has been going on for 6,000 years, it's not going to stop today. But then again, it's been going on for 6,000 years, and people are still finding justice. It's just that it's not the way we think it is. Everything is political. And once you shift to politics, it's just as effective. It's just a different way of thinking about it. And if you go in as a pro se, the lawyers will tell you, if you go in with a pro se, you don't know what you're doing and you'll get clobbered. Well, the truth is the courts hate pro se litigants. But they don't hate pro se litigants because they write stupid pleadings. They like that part. That's easy for them to screw them. They hate pro se litigants because every once in a while they come across Leslie. They come across the pro se from hell. The pro se who understands that the pro se has powers and abilities far beyond those of mortal attorneys. You can kick the courts behind every way from Sunday, and there is nothing they can do about it. That's why they hate pro ses. You have abilities lawyers don't have. You can take that judge to task in a way a lawyer never would. And you can take the other lawyers to task in a way that another lawyer would never do. So first we get all the details. And with all of that said, for the most part, the courts will...
Two real quick questions. I just want to know, this is what somebody told me, and I try not to go on people I don't know. You have really, gosh, your name has come up since I heard your name. You're next to almost God Almighty, or serve under God Almighty, basically. Somebody told me, Kelly, you became a case law. That is almost impossible to do. That proves how corrupt your judge was. Is that true? Is that... No.
Okay. The judges... Okay. People are, for the most part, we're right-minded. I don't know if God created us or if we just evolved. But if we evolved with empathy. We evolved with a sense of justice. Everybody has it. The thing that you and I don't understand is where that judge lives and what he has to deal with every day.
Right. And
what the police have to deal with every day. The police, for the most part, deal with about 7% of the population. And that 7% are just habitual criminals. They're wacko. And then when a policeman stops you, he doesn't know that you're not part of that group. And it takes a while for him to realize that you're one of the good guys. So we wind up getting angry and frustrated at the police. It's because we don't understand what they have to deal with every day. Once we get that down, we won't feel so angry at the courts. One thing to understand about the judge has two duties. He must determine the facts in accordance with the rules of evidence, then apply the law as it comes to him to the facts in the case. That's his only job. And I've told more than one judge that come in and is getting all upset and pushy and angry. Say, Your Honor, if you have another agenda, you need to get down off that bench and cause yourself to be replaced by the fair and competent jurist I have a right to in the first instance. And the reason I can do that is because when I walk into a courtroom, I am the baddest motor scooter in the building. Yeah. And there's only one reason I'm the baddest motor scooter in the building. And that's because I'm not a judge. I'm not a bailiff, a court clerk, a lawyer. I'm nobody. All of these people are public servants or quasi-public servants. They're the servants. I am the master. And they are not to forget it. Because if they forget it, I will introduce them to the deep end of the pool. This is what I can teach you. I can teach you how to stick it to that judge big time. And when you start sticking it to the judge, he can't come to you and complain about it. He has no influence over you. But that lawyer on the other side, he's in there dangling by his bar card. That judge can work that lawyer over.
That's the one I like to see this work.
Yeah, going to court is like sitting down at a four-sided chessboard. You sit down, you've got your lawyer to your right, you've got opposing counsel to your left, and you've got the judge across from you. Well, you have a relationship with your lawyer. Your lawyer has a relationship with the other lawyer and the judge. The other lawyer has a relationship with the lawyer and the judge has a relationship with both of the lawyers. You're the odd one out. If you are to win your case, you have to be able to manipulate your lawyer's relationship with the judge and the other lawyer. It's all politics, and it's not that hard. You have to give your lawyer plausible deniability while you're kicking their behinds. So that your lawyer can go to them and say, I'm sorry my client is kicking your behinds, but I can't do anything about it. If you will help me out, I can get my client to quit kicking your behind. But if I don't do something, she's going to kick my behind. So help us out here, guys. Let's find a way to get this dirty, rotten pro se to quit beating all of us up. This is how it works at the end of the day. And this is what I'm going to show you how to do. Does that make sense?
I'm trying to help other people get in. But you were talking about with my foreclosure. You said you wanted me to get a HUD-1 settlement statement because you'll see charges of closing. Was there something else you said you wanted me to get?
Yes, a truth in lending statement.
Truth in lending statement.
Yeah, and the note. Once I have all of that, I'll take a look at it. I'll run some calculations on it. I've got some spreadsheets that I spent 6 months building that I'll run the numbers through the spreadsheet. And I'll give you more claims against these guys than you can shake a stick at. You can keep them all in court until they all get old. Hang on. Going to break. Randy Kelton, Real Radio. Our call-in number, 512-646-1984. We'll be right back. I didn't forget about you, Oliver. I still see you there. We'll get to you. Hang on. We'll be right back.
Are you a knuckle cracker? For some, it's a nervous habit. For others, it brings a sensation of relief. But is it harming your joints? I'm Dr. Catherine Albrecht, and I'll have the answer to that white knuckle question in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Snap, crackle, pop, ouch. It's another annoying knuckle cracker on the loose. If you enjoy cracking your knuckles, someone has probably told you it can lead to arthritis. But is there any truth to that? The research on knuckle cracking is admittedly thin, but in the most comprehensive study to date, published in 2011, researchers found that people who pop their knuckles every 15 minutes were no more likely to develop arthritis than those who did it just once a day, or those who didn't crack their knuckles at all. So if you like cracking your knuckles, by all means carry on, but please do it where the rest of us can't hear you. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
We'll be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me for? Free toilet? Who you want chip? Me no free toilet. You can't chip me. How am I say? Don't let them chip you in the morning, chip you in the evening. Put a chip in your body. And then when you go computer reading, you can't hide me from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the grandme.
Okay, we are back. Randy Kelton, Real Radio, and we're talking to Kelly in Pennsylvania. And Kelly, I have to kind of apologize to you because...
No, I got a lot of work to do.
Well, this is a teaching show, and I went beyond what you're actually asking for because I'm trying to put out the basic structure so everybody listening understands where we're going to and how this leads to a positive outcome. It's not straightforward. It's not the way you would expect. It's certainly not the way they taught in high school.
I thank you, Randy, for your time, for me, as well as for everybody else, because even listening to the two people I got to hear while I was holding for you, I learned some things. So thank you for helping and sharing your wisdom with others. And okay. I will work very diligently. I think you'll be very pleased with the timeline because of my journaling.
Good. I'd like to work with people who keep good records because it gives me a lot to work with. And we can give you a lot of things that you can use. And I will, if you will send me an email to randy@ruleoflawradio.com and ask me for an introduction to Leslie, I'll forward that to Leslie and she will contact you. Leslie is wonderful. And Leslie she does not take the prisoners.
Okay.
Good. She's going after a district judge now with criminal complaints. She is working them over.
Good for her. Well, when you hear what they did to me, it's disgusting. And I know people that have committed suicide for far less than what they did to me. And that's why my journaling kept me alive.
I have a friend that went to family court, and the judge forced him to give up every asset he had, even assets he had before he was married. He went home and stuck a pistol in his mouth and blew his brains out. I consider that depraved heart murder. So sure. I do want to go after these guys. We have judges on there that forget who they are. One of my favorite quotes is H.G. Wells in his Outline of History on speaking to the corruption of the popes during the Dark Ages, very aptly observed, "The giver of the law most owes the law allegiance. He of all beings should behave as though the law compels him. But it is the universal failing of mankind that what we are given to administer we promptly presume we own. It is my purpose to help ordinary individuals learn how to remind these public officials that they are the servants, we are the masters. You cross one of us, and we will take you to task. If you heard the first part of my show, I just went and filed first-degree felony aggravated assault charges with the local grand jury against my district judge. You want to have yourself an attitude, Bubba? I will introduce you to the deep end of the pool. This is what you and I can do because we are the process. And if I can get you kicking their behinds there, that's why we do this show.
You're going to be shocked when you see what they've done to me. I'm doing this.
You know, I really hope that I am, but I am so jaded. I hear so many horrible stories. It breaks my heart.
That's true. That's true. I mean, I'm in a bank doing my banking at a teller, and my husband comes in, 6 foot tall, 230 pounds. I'm 5'9", 97 pounds, and he beat me from head to toe.
In the bank?
And in a bank parking lot. I was at the teller, and there was a tap on my shoulder, and it startled me. You know, when you're at the teller, you know, unless somebody's with you, you don't expect a tap on the shoulder. And it was my husband. So he walked me out of the bank. We were talking, and I had my rehab dog in my car with me. And I said, look, Bob, you can't have it both ways again. You can't have a wife and a mistress. So you pick and you choose. And he said, I can't do that to Wendy. I'm here to take the dog. And I said, you got a dog. Her name is Wendy. And I just tried to get in my van, and he beat me literally from head to toe. I bit him in self-defense, and I went to jail because the police said that they cannot charge two people with assault. He said he was doing his banking. I said, officer, he did not do any banking. Please go into the bank. I was at the very first tower, and she saw how startled I was when he showed up. He asked Mr. Bingaman to produce his receipt from the banking because here's mine. And he said, don't you tell me how to do my job. Not one of the 8 officers walking out.
That is my pet. Okay, that's my pet peeve. That's the one I would most enjoy helping you go after. Policemen with attitude, I know how to adjust their attitude. That we will look at, that we can handle. From my perspective, that's most important.
Criminal charge off my record. Is that possible? I can't even get a volunteer job because of that criminal record.
Okay, I'll have to see. Did you get a? Okay, hold on. Did you get a conviction on that issue?
Yes. I went right from jail to the ER. 3 doctors testified I was assaulted. I went to a lawyer. I was assigned one of them attorneys that the courts assign you, and I showed him. They took pictures of my body. And 3 different doctors had to look at me, and they all documented that I was a victim of an assault. And the court-appointed attorney said, we can't use any of this in court. But if you hire me under my own private practice, we can use it as evidence.
Okay, I will show you how to go after the attorney. Okay. This is all politics.
So much to this
the attorney is court-appointed. And he merely uses that as a way to try to extort money out of you. I'll show you. The attorneys are the most vulnerable. So we'll show you how to go after them. First thing, give me a timeline on each of the issues.
Yes, sir.
Email it to me.
Do you want that in there too? Like the beating and all that?
Yes, absolutely. Absolutely. Put that in there.
Okay, sir. Thank you. God bless all of you. Okay. I will keep you all in my prayers.
Okay, thank you.
Andy.
Okay, now we're going to go to Oliver in Tennessee. Hello, Oliver. Oliver, are you there? I think there's a good chance I put Oliver to sleep. I have that effect on people. It's my eloquence that does that. I won't accept the fact that I may have bored him to death. Oliver, if you can hear me, I can't hear you. I can't hear you, Oliver. So, okay, let me unmute you again. Hello, Oliver. Are you there?
Can you hear me?
Gotcha. Okay. I thought I'd put you to sleep.
No, I'm sitting here listening.
I have that effect on people. Okay. So this is Oliver, and Oliver is been jerked around by the police, and now instead of the jerk-e, he's becoming the jerk-or. So what has happened since we last talk? You went to the chief of police and filed criminal charges, and he got all upset and stormed out of the building. Okay, Oliver was charged with 2 or 3 different things. He got them all dismissed. And then he went back to file charges against the officer. So where are we at on that now?
The chief said he wouldn't take him. He left out. I talked to you. When I talked to you, I went and called the city's mayor, talked to their office, told them what I was trying to do. Then they told me that, well, I can't talk directly to the mayor. There's a process for this thing. And I do have a grievance, but they referred me to their audit department, internal audit department. So I went there and I told them what the problem was. And they told me, well, they're going
to... Hang on. We're back to go to break. We'll pick this up on the other side. This is Randy Kelton, Deborah Stevens, Real of Law Radio. Won't even give out the call-in number. We're going into our last segment. So hang on. We'll be right back.
Hello? Oh, man. In jail? You got busted up? Oh, man. I'm broke,
dude. Okay, we are back. Randy Kelton, Deborah Stevens, Real Law Radio, and we're talking to Oliver in Tennessee. Okay, Oliver, what is happening now?
After I called to you the next morning, I just called up to the office at first just to send some fire down the chimney. Then we went along with our way. I went to get the videos. Before we went to the mayor's office, we decided to stop by the police department again and try this complaint thing on another issue, on another situation. We walked up to the teller, and we told the teller, hey, we want to file complaints against the officers, the situation that happened a couple nights ago. And it was like we was in another world. The teller was, like, extremely nice. Like, it's immediately, I'm going to go get this paperwork for you. If I'm going to see if we have any more paperwork. If not, I'm going to contact the person and get it right down here immediately. Me and my friend are looking at each other like, is this the same rude people that we were dealing with the other day? I mean, it was different. So she hooked us up with the lieutenant over the two guys so we can file a complaint. She was not there at the time. She gave us the time, her schedules, that she was going to be there to come in and speak to her personally. And they were going to accept the complaints. They were going to accept the complaints and everything. So then,
funny how that works. when you go above their head, you see that mayor, he has to be elected. And when the mayor has to answer to a citizen, especially if the citizen is crawling down his throat, he is not going to be a happy camper. Well, you have to be careful. I remember I warned you.
Mm-hmm.
This could get to be way too much fun.
Well, exactly, because I went to the audit office and I went in there and told her my issues, and like she clarified what the audit department was, and as she was clarifying what the audit department does, I'm sitting here like, what? You just threw the policies underneath the bus. You just told me how to attack the policies through your office before I take it up any higher. So what I wanted to ask you, because I asked her and she kind of was like looking at me like, I don't have any idea what you're talking about. How do we file against the police officer's bond? I heard that's a big incentive.
You send a tort letter. Well, the way to file against them, I don't know that there's a direct way to file against the bond. When you file, you have to sue the city
first.
Yeah, and that's a lot easier than you think it is.
Okay.
If you file suit against the city because of this police officer, and the court takes your suit and throws it out the window, it don't make any difference. His bond rating goes through the roof.
Oh.
And lawsuits are easy. We think, everybody, they sit back thinking about, how would I write a lawsuit? Well, you don't. You go down and look in the public records and look at the other people who have sued. You got other people who paid a lawyer to write up a lawsuit, and what the cops are doing to you, they did to them. And you'll find a suit that goes right to your issue. If it's not this city, some other city, you look in the district court records and look through the suits. When I first started taking on the system, my legal education amounted to me going down to the district court and pulling court records and just reading cases. I asked the clerk to bring me the biggest case that you have. And she said, what? The biggest? You mean the most important? No, I mean the biggest. The one that takes up the most room in your files. And she brought out 3 filing cabinet file drawers for one case. It was Mitchell Energy. Have you ever heard of fracking in the oil industry?
No.
Okay, well, Mitchell Energy figured out how to frack. We had a layer of shale with oil in it, but it's all trapped in the shale. And Mitchell Energy figured out how to drill down into the shale and then turn the bit 90 degrees and drill laterally in the shale and then set off charges down there to crack up the shale so that the oil would leach out of it.
Right.
But they didn't case their wells very good, and that oil leached up and got into the aquifer and contaminated the groundwater.
Right.
And they got sued. It was, at the time, it was the biggest settlement ever in history. Well, it was 3 file cabinets full. And I pulled that out and started going through it, and you just find this magic stuff in there. These were high-level, expensive attorneys, the best of the best. And I pulled out an in limine motion I could not believe. I didn't even know what an motion in limine was. I saw that. Motion in limine. What is this? And I got it. It's all the stuff they can't ask in court. So go down and look for lawsuits against the city. And just pull out a few of them and read them. They'll show you how to file them. They'll show you how to argue jurisdiction, how to argue qualified immunity. They'll show you how to do it. If you're going to take these guys on, there's one skill you must hone beyond all others. You must become an accomplished plagiarist.
Right.
If you're writing your own motion, you hadn't done enough research. Somebody else already wrote it. You need to go find a lawyer who's written it and steal his stuff.
Right.
And it won't take you long to get this figured out. And you'll be filing documents with the court that they won't believe. So they're going to look. Actually, they'll know exactly how you did it.
Okay, so the actual suit in district court is what's going to cause the effect of the bond.
Yeah. Well, first file a tort letter, and you have to file a tort letter and give them 60 days to make you whole or be sued. When you file a tort letter, and all a tort letter is saying your officer acting at your request did this, that, and the other, and they harmed me in this way, and you owe me this much money to make me whole or be sued. When they get that letter, they're going to go bonkers. And the mayor is going to go charge down to the police department and want to know what in the heck is going on. What did you do to cause us to get sued?
Okay, so I send that tort letter to the city mayor.
Yes. Oh, and it is so much fun. What I like to do is actually write the suit that I'm going to file. And then I put a business letter heading on it. Instead of a prayer at the end, I put "Make me whole or be sued" and sign it. So when their city attorney gets it and he looks at it, he's going to tell them, "This guy's not kidding. He's already written the suit because here it is." They're going to get real excited, and a good chance you won't have to sue. You send them a good tort letter, and all of a sudden you will become Mr. Oliver. Yes, sir, Mr. Oliver. What can I do for you, Mr. Oliver? Which cheek would you like me to kiss, Mr. Oliver? Because the mayor's, these guys are like toadies on the high school parking lot.
How do I spell the tort? So I can make sure I take a good look at it, the definition, before I go write it up.
Wait, tort. Okay, tort letter. What they did to you was rings in tort as opposed to ringing in a cause of action. If it rings in civil causes of action, I should have said rings in contract. Your claims will ring in contract or they'll ring in tort. If you and I enter into a contract and I breach the contract, you will sue me based on contract and you'll claim causes of action. But say I'm driving down the road and a city worker swings a backhoe bucket around and puts it through my car window. I don't have a contract with the city. That's a tort. So the police, they do something that they shouldn't have done. You don't have a contract with these guys, so that rings in tort. So you send them a letter notifying them that you have been harmed and for things that aren't in contract. Does that make sense?
Yes. How do you spell that, the tort?
T-O-R-T.
T-O-R-T. Okay.
Yeah, and just go on the internet and look up, the municipality this occurred in, space tort letter. You're likely to find some tort letters that were sent to the city.
Okay.
Or look for another city that's a little bigger. Find some that somebody else has had a lawyer write up, and then just write it up the way they did and put your facts in it.
So now, let's say if they do meet my demands, does that mean I can't sue them in court anymore?
Yeah, you don't need to. You tell them,
so that means
you harm me to the tune of $60,000. Make me whole or be sued. If they give you $60,000, no problem. But they are not going to do that. Most likely, they won't even respond to your tort letter, or they'll just deny everything. But a tort letter is a statutory requirement.
Okay.
But when you file it, the mayor's going to be going down to the police department and crawling right down the chief of police's throat. And when he gets done, the chief is going to be crawling down on his cotton's throat. He don't care if he was right, wrong, or what have you. You got me in trouble, you're in trouble.
Do I send it certified mail?
Certified all ways. Return receipt. Okay. Thank you, Oliver. We're out of time. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. We'll be back tomorrow night on our 4-hour info marathon, so make sure you tune in. And as soon as we close out, you might go to Logos Radio Network and check out our sponsors. If there's anything you need that you can use from them, it will help keep the show on the air.